That's the demon that you're after here. That is the only reason we've got this issue. Now, the custodian of those documents holds and exercises a privilege on behalf of the Bush administration. These are documents we would otherwise not have access to because they are privileged. Pursuant to an agreement with the Senate, as an accommodation to the Senate, the custodian of those records has agreed, notwithstanding the privileged nature of those documents, to hand them over to us with an understanding that when there is a need that arises with respect to one or more of those documents to make them public, we can, as a committee, go through a process to do that. That is exactly what has happened. It's what has worked, and it's what has worked here today. So if you're frustrated with the process, then let's review the Presidential Records Act. But we're just doing what the law allows us here to do. These documents are not ours. They belong to someone else. It is not written into the Constitution. It's not written on stone tablets anywhere that we're entitled to documents that don't belong to us. It's significant that William Howard Taft didn't release his presidential papers. It's significant that Robert Jackson, having served as Attorney General, didn't release all the papers he had as Attorney General. Why? Well, I assume it had a lot to do with the fact that they didn't belong to us as a Senate. If we want to be able to have a process, not just with this administration, but in every presidential administration, Democratic, Republican, or of any other stripe in the future, we need to respect the process and respect the privilege that is accorded to documents that do not belong to us. That's all we're asking. And the process is working. Let's move forward.
Mr. Chairman,
Yeah.
on behalf of this side, I would like to just say a couple of things. There is no process for the committee confidential. It used to be that both sides had to concur, the chair and the ranking member. But now this is just simply not the case. To some extent, with this kind of thing, committee confidential becomes a kind of a crock, and it shouldn't. I think we need to sit down. I think we need to have a rule on how committee confidential is determined, on what it means, and who makes that decision. For all I know, some Republican staffer could have made the decision, and I just don't know. Documents appear. Our side had nothing whatsoever to do with the designation of committee confidential. So it becomes a way, if there's no rule, for the majority to essentially put all information through a strainer. Should we let this go out and be public, or should we not? And I don't think that's what this committee is about.
Mr. Chairman?
You know, in the absence of a majority of a committee opposed, the chairman acts on behalf of the committee, and Chairman Leahy accepted documents on a committee confidential basis during Justice Kagan's nomination, and there's no indication that the ranking member agreed to that at that particular time. Senator Coons.
Thank you, Mr. Chairman. Just two quick points, if I could. First, the question's been raised. Whose documents are these? These are the American people's documents. The Presidential Records Act gives us a right to obtain them for a Supreme Court nomination after the review of the professionals at the National Archives. And Bill Burke is not a professional at the National Archives. The Archives has said that this is not their process. Equally importantly, because some will now make dire predictions about the appropriateness of the release of any of these documents, Bill Burke himself, in his letter to us of August 31st, said, and I quote, that Presidential Records Act Exemption 1, which protects against the disclosure of classified information, did not apply to any documents our team reviewed. I agree with Senator Booker. This confirmation is too important for us to conceal documents that may reveal the nominee's views, and I think we shouldn't be proceeding under these grounds.
Mr. Chairman? May be recognized, sir.
I hope you don't say the same thing again.
Sir, I will not. And first of all, I will say something that I haven't said, which is I appreciate the patience of Job that you're showing here. And I just also want to say that the representations from Senator Kennedy and Senator Lee were right on point, right on correct. They stood strong last night, challenged me, but they not only were collegial, but they look to find a fair way to deal with this process, and I want to express my appreciation. I want to clarify something that I said before. There is no Senate rule that accounts for this process, period. This is not a Senate rule. I did not violate a Senate rule. But I will pause. There is no Senate rule that I violated, because there's no Senate rule that accounts for this process. And I say to a chairman that I respect, that I believe has been fair and good to me, I will say that I did willingly violate the chair's rule on the committee confidential process. I take full responsibility for violating that, sir. And I violated because I sincerely believe that the public deserves to know this nominee's record. In this particular case, his record on issues of race and the law. And I could not understand, and I violated this rule knowingly, why these issues should be withheld from the public. Now, I appreciate the comments of my colleagues. This is about the closest I'll probably ever have in my life to an I am Spartacus moment. My colleagues, numerous of them, said that they too accept the responsibility. There were very serious charges that were made against me by my colleague from Texas. I don't know if they were political bluster or sincere feelings. If what he said was sincere, there actually are Senate rules governing the behavior of senators. If he feels that I, and now my fellow colleagues who are with me, have violated those rules, if he is not a tempest in a teapot, but sincerely believes that, then bring the charges. Go through the Senate process to take on somebody that you said is unbecoming to be a senator. Let's go through that process, because I think the public should understand that at a moment that somebody's up for a lifetime appointment, that this issue, does the public have a right to know? This is not about the Presidential Records Act. This is not a violation of the Presidential Records Act, not a violation of Senate rules, sir. But if somebody's going to land those charges, I hope that they will follow through with me and Senator Durbin, Senator Coons, Senator Whitehouse, Senator Hirono, Senator Blumenthal, now Senator Feinstein. I hope that they will bring charges against us. And I'm ready to accept the full responsibility for what I have done, the consequences for what I have done, and I stand by the public's right to have access to this document and know this nominee's views on issues that are so profoundly important, like race and the law, torture, and other issues.
Mr. Chairman, may I read the Senate Rule 29.5, the standing rules of the Senate for the benefit of all senators? Any senator, officer, or employee of the Senate who shall disclose the secret or confidential business or proceedings of the Senate, including the business and proceedings of the committees, subcommittees, and offices of the Senate, shall be liable, if a senator, to suffer expulsion from the body, and if an officer or employee to dismissal from the service of the Senate, and to punishment or contempt. So I would correct the senator's statement. There is no rule. There is clearly a rule that applies.
Then apply the rule and bring the charges.
Mr. Chairman, all of us are ready to face that rule on the bogus designation of committee confidential. Just because there is a Senate rule doesn't mean it can be misapplied or misconstrued or misused. And I think even the threat raised by one of my colleagues here is unfortunate. And that is a kind way of putting it, with all due respect. And I would just make one other point. We're dealing here with a lifetime appointment. Nothing we do here is more serious than confirming a justice on the United States Supreme Court. Let the American people appreciate that we are here in the most solemn responsibility we have under the Constitution. We need the full truth. Just as this nominee is sworn to give it to us, we are entitled to it from our colleagues. And the question is, what are they concealing by this procedure? What are they afraid the American people will see? What are they afraid we would be asking of this nominee if we had all of those documents that have been denied us in this sham and charade?
Senator Lee, then Senator Tillis.
To Senator Booker's point, the document you're talking about has now been approved through the committee processes. It's been made public. The process worked. And I pledge to work with each and every one of you. If you got a document as to which a privilege has been asserted, such that it's not public yet, I'll work with you to try to make it public. Let's do it. I think we can do this. It's not that difficult. We've done it several times, at least 3 times now. We can do it more. The privilege thing is real, though, and this is not our privilege we're dealing with. This is the privilege that belongs to somebody else. And the privileged nature of documents has been around for a long time, since the early days of the Republic. The records, the notes of the Constitutional Convention were ordered sealed for 30 years after the Constitutional Convention occurred in 1787. I'm not sure all the reasons why, but those who participated in it decided that that was going to be the rule. Sealed 30 years. Those documents didn't belong to anyone else. They belonged to those who attended that convention and participated in it. Now, there were at least 2 from that list, Oliver Ellsworth and James Wilson, I believe, who were subsequently nominated to serve on the United States Supreme Court. No one demanded, to my knowledge, and no one could have gotten, notwithstanding the 30-year seal agreement, the notes to the Constitutional Convention, even though those certainly would have been probative as to how those people might have served on the Supreme Court. And yet no one was accusing the United States Senate back then of being a rubber stamp for the Washington administration or anyone else. In fact, in 1795, the United States Senate disapproved of at least one of President Washington's Supreme Court nominees. This was no rubber stamp. And yet they respected the fact that they didn't own every document, that other people might own them. We don't own these, and so we have to go through the process, a process ordained by a law that we passed and that only we have the power to change. Let's follow that law. We can follow the law and respect the process and respect the rights of each of our colleagues and the rights of the American people to review documents that might be relevant here. But let's go through the appropriate process to do it.
Mr. Chairman,
I think I ought to be fair to the
I
Republicans.
think you should too.
Okay, go ahead, Senator Tillis.
Thank you, Mr. Chair. Mr. Chairman, I took nearly 17 years to get my college degree. I went to 5 different institutions. I'm pretty sure none of them have been elevated to the Ivy League. That's right. I don't ever plan on running for president in 2020 or any point in the future. I want to make one more comment and then one request. The comment is, I hope everybody will record a transcript of what's going on right now. Senator Lee explains things, I think, in eloquent legal terms, but let's talk about the consequences of making this an untrusted body to receive documents under the Presidential Records Act. You may rue the day that you do that because you'll probably get fewer documents in the future. Now, what I would like to do is ask all of my members is perhaps we can actually demonstrate to the American people that we're prepared to expose our own records. I would like to suggest, for the purposes of the SCOTUS nomination, that all of us waive any right to the speech and debate clause and that we allow all of our email records related to the SCOTUS nomination to be made public on an immediate basis. I, for one, am ready to sign up for it now. I hope all my other members would do the same thing because in the interest of transparency, certainly it would make sense for every one of us, regardless of what we want to do in the future, to expose that information to the American people.
Are you done? I'll start with my questioning. By the way, we're going to have to protect so everybody gets an opportunity to look at the FBI and anything else you want to ask at 1 o'clock. We're going to have to go into executive session and get that done before, if the Senate does close down at 2 o'clock. If they don't give us permission to meet after 2 o'clock, we've got to get that out of the way. So we'll do that at 1 o'clock.
May I just put a document
Chairman, would
in
you
the
yield to a question? Mr. Chairman, would you yield to a question about procedure?
I used the wrong word, closed. We're talking about closed instead of executive session. So,
Would you yield to a question about procedure, Mr. Chairman?
Go ahead.
Could you explain to me why we're having to truncate the hearing today?
Well, I'm not sure we do have to truncate it, but just in case Well, it would be because the minority may object to the unanimous consent